Good afternoon, everyone, and thank you for joining me today for our webinar entitled Immigrant Visa Options for Scientists and Researchers. My name is Jessica Marks. I'm an associate attorney with Wolfdorf Immigration Law Group, and today we're going to be focusing primarily on self-sponsored immigrant visa options, meaning that no employer or company is required in order to pursue lawful permanent residence or the green card in the United States. And then toward the end, we'll be discussing the EB-1-2 Outstanding Researcher and Professor category, which does require a sponsor, but is a great option for those of you in academia or private industry that have already ascended to permanent positions in your career. So to jump right into things, we're going to begin with the employment-based first preference first immigrant visa category, or EB-1-1, also sometimes called EB-1A. This category is reserved for foreign nationals of extraordinary ability, and there are several different fields in which you can have extraordinary ability to qualify for this classification, but we're going to be focusing on the sciences. There's also the arts, the education field, business, but again, we're just going to be talking about the sciences, even though the same criteria that we're going to be discussing do apply to those other fields as well, just in case you're contemplating a career change. So as I said, this is for foreign nationals of extraordinary ability, and this is for recipients of a one-time major international award or achievement, such as the Nobel Prize or an Academy Award. And failing the earning of such a one-time achievement, you can still qualify if you satisfy at least 3 out of 10 criteria, evidencing that you have risen to the very top of the field. So that right there tells us that how you define your field is very important to the case, because the larger the field, perhaps the more difficult it is to have already reached the top of it, especially if you're at an early stage of your career, such as pursuing your doctoral degree or maybe even in your postdoc. So for example, instead of saying that you have reached the top of the field of medicine, you may say gastroenterology, or even being more specific, inflammatory bowel diseases. So that it's important to discuss that with your attorney from the very outset of the case so that the field can be defined, and then the discussion can follow of the evidence you have of already having risen to the top of that field. This can actually be self-sponsored or sponsored by an employer. So if you do have an employer willing to sponsor you, you can pursue it that route. But if you have not yet received a permanent job offer, you can sponsor yourself. The O1 is the non-immigrant, excuse me, the non-immigrant mirror of the EB-1-1 category. Non-immigrant meaning for a temporary specific purpose and bound to an employer generally, and the EB-1-1 being the immigrant version. There are similar criteria in order to establish eligibility for the O1. So if you already have it, then an EB-1-1 may be within your reach. But even though the standards are the same for the sciences, being one of that small percentage to have already risen to the top of your field, in practice, we see that the immigration examiners are much stricter and stingier in granting EB-1-1 classification compared with O1. The first step in proving your eligibility and analyzing whether this may be the immigrant visa option you want to pursue is considering the different criteria that you may satisfy with your career achievements. So as I mentioned before, you have to satisfy at least 3 of the 10 criteria if you don't have that major international award. The first 5 you see here up on the screen. And one thing that you may immediately notice, and that I want to call your attention to if you don't, is that when we're talking about criteria and there being 10 of them, I like to think of there actually being several criteria within each criterion. Because if you look at the first one, for example, lesser nationally or internationally recognized prizes or awards for excellence in the field, there's actually 2 different standards and types of evidence or burdens of proof that you have to meet in order to satisfy that single criterion. First and foremost, you have to establish that it is a nationally or internationally recognized prize. How do you do that? Well, maybe each year the society or association or organization in your field that issues the prize or award issues press releases after the award has been granted or leading up to the meeting or conference at which the award is going to be presented. They announce what the criteria are going to be for that award. Past recipients of the award who are themselves extraordinary individuals. There's all different kinds of strategies for establishing that the award is lesser nationally or internationally recognized prize, but you have to think about that. Even just getting an award or a prize is not sufficient. It has to be nationally or internationally recognized. So, for example, a regional or a local award or prize is not going to satisfy that standard. Secondly, it has to be for excellence in the field. So it can't be something that the, excuse me, it can't be something that everyone gets by virtue of participating, for example, in a workshop. It has to be something for excellence, having accomplished something in the field, and that you are being given the prize or award specifically because of that accomplishment or contribution. So when you're looking at the criteria, again, I just want to stress that you can't just focus on one or two words: prize, award, membership, judge, contributions. You have to look at the criterion as a whole and determine how many things do I have to prove in order to satisfy this single criterion. So we've covered the first one in pretty thorough detail. Moving on to the second, membership in associations that require outstanding achievements as judged by recognized experts in the field. I'm sure that everyone here listening has at least one membership. You're probably, members all the way back to your student days when you got a special student rate on membership in the American Association for Cancer Research. That is not the kind of membership that we're talking about. We're talking about people who are elected fellows or who have ascended to a certain level of membership that requires an outstanding achievement, not just simply paying your annual dues. And then the last part of that criterion, as judged by recognized experts in the field, you have to provide evidence showing that you were granted membership in the association based on the recommendation or evaluation of experts in the field. The third criterion, published material about the applicant in professional or major trade publications or other major media about the work in the field. USCIS has been particularly stingy with this criterion, trying to say that published material needs to be in the plural. It's not enough to submit just one evidence about your research that was published in the New York Times, which of course is ridiculous because that is absolutely evidence of recognition for your achievements in the field in a major U.S. publication, no less. So don't accept what they say. Fight with USCIS if they're being unduly restrictive in granting you a criterion, but that's something we'll talk about more later. So the published material does, however, have to appear in a professional or major trade publication or other major media. And even though it says about his or her work in the field, again, immigration has continually tried to restrict this criterion by saying it has to be not just about you or your work, but it has to be primarily about you. It has to mention you by name. It can't just be about an article with, that you published without your name anywhere. They're going to be very stingy about this one, but don't let them get away with it. If there's review articles, editorials that have been written about your work that are published in one of the journals in your field, you can certainly satisfy it that way. Science Daily, we argue that those types of websites satisfy this material, but one thing that can make that a little tricky is that the criterion requires that the published material reflect the author's name. And a lot of the time, these publications, especially online, are recycled press releases that don't have an author. So unless you have a published material with the author's name, the date that it was published, and that kind of basic information that you're used to seeing in connection with an article or other published material, it's going to be difficult to get USCIS to give you this criterion. Moving on to the next, participation as a judge of the work of others in the same or an allied field. For the researchers and scientists, this one is generally pretty easy to meet. If you've done peer review work for journals, you've participated in the manuscript review and selection process. Now, in terms of the type of evidence that you want to submit in order to establish this criterion, it can get a little tricky if, for example, you have been performing the review work, but it's been at the request of your PI, who is the one that has actually received the request from the journal. So even though that may meet the plain letter of the criterion, that may not be considered evidence of your extraordinary ability because you didn't personally receive the request. And that's something, again, that we'll talk about a little later when we get to the second step, which is the final merits determination. Right now, the first step, still talking about the criteria. The fifth there is the original scientific contributions of major significance to the field. So again, it has to be original, and it has to be of major significance. So just simply being an original discovery or original research work publication isn't going to be sufficient. You have to demonstrate that it is considered of major significance to the field as a whole. Moving on to the next 5 criteria. Again, authorship of scholarly articles. This should be a very easy one for almost everyone out there listening to satisfy. If you are a researcher and a scientist, particularly if you're in academia, it's publish or perish. So if you have written any papers that have been selected for publication in professional or major trade publications or other major media, you're going to get this criterion no problem. Display of the applicant's work in the field at artistic exhibitions or showcases. That word artistic is problematic when you're working on an EB-11 case in the sciences because immigration has very firmly taken the position that that criterion can only be satisfied by artists. We'll talk about that in a second. Moving on to the next criterion, performance in a leading or critical role or organizations or establishments with distinguished reputations, commanding a high salary or other significantly high remuneration for services in relation to others in the field. Sorry, if you're a postdoc or a PhD candidate, you're probably not going to meet that one. And then evidence of commercial success in the performing arts. So there's that word again, arts. So it looks like of the 10 criteria, immigration has already taken 2 of them away from the scientists and researchers because they exclusively apply to artists. But maybe we shouldn't let that bother us because there is something called comparable evidence. In the EB-11 regulations, they specifically allow for comparable evidence of extraordinary ability to be submitted when the 10 criteria do not readily apply to the applicant's occupation. And this is another area where we've had some fights with USCIS and had to do a little back and forth on what that regulatory language actually says and what it allows, because immigration sometimes takes the position that it's not just that one of the criteria don't apply and then you can do comparable evidence. You have to argue that none of the 10 readily apply to your occupation, and then you can do comparable evidence. I've successfully argued with them on that. I think that other attorneys have as well. It's just difficult because when you receive an approval of a case, they never tell you which criteria they gave you and which they didn't, so we don't know how often immigration accepts that argument, but nonetheless, you can always argue it. So I gave that example of the evidence of success in the performing arts as not readily applying to occupations in the sciences. So while you can't satisfy the plain language of that criterion, you may be able to argue that comparable recognition for achievements would be your presentation at prestigious national or international conferences in the field. So again, regional, local, grand rounds, presentations in front of your department, that's not going to be very impressive. But if you're consistently having poster presentations and even better paper or oral presentations at the most important national and international conferences, workshops, meetings that are relevant to your field of endeavor, then that's going to be persuasive evidence, and it's going to be particularly persuasive, as you see there, if it's invited. Anytime that you have a correspondence, a letter, an email sent directly to you, that is always going to be the best type of evidence because it indicates that the field has recognized what you've already accomplished, and therefore perhaps that you have already risen to the very top of that field. Now, I've been alluding to this second step, the final merits determination, during the discussion of the first step, which is the satisfaction of at least 3 out of the 10 criteria. And the reason that this second step is so pervasive and always rearing its ugly head when we're talking about evidence in support of EB-11 petitions is because if you satisfy at least 3 or even, let's say, all 10 of the criteria, what the heck, that does not necessarily mean that your petition is going to be approved. At this second stage, when immigration reviews the evidence as a whole to determine whether in its entirety it paints the picture of an extraordinary person, they may say that even though you satisfied the minimum or let's say even the maximum number of criteria, you still are not eligible for classification as a foreign national of extraordinary ability. And how they get about saying this is basically that it's not just quantity of criteria, it's quality of the evidence. And I don't necessarily, disagree with them on that point, because if you look at the third bullet point there, if we look at the example of you having reviewed a single manuscript, authored a single paper that was published in a scientific journal, and received 1 award over the course of your entire career, which depending on who you are, that could be 2 years or it could be 20, that is going to satisfy the plain language of those 3 regulatory criteria. But that evidence, those 3 pieces of evidence, do not demonstrate that you are at the very top of your field. So whenever you're talking about what evidence do I have of my extraordinary ability, you can't just think of it in terms of, well, how many criteria do I satisfy? You have to think of it in terms of, is it consistent with the overall standard that you have enjoyed sustained national or international acclaim and a recognition for your achievements? Some of the issues that are specific to scientists and researchers, like I said, there are a lot of criteria that are going to be easy for you to meet. But in terms of the quality of the evidence that you're going to be submitting for scholarly articles, the rank and impact factor of the journals in which your papers have appeared is going to be important. If you're consistently publishing in some of the least cited, lowest impact journals in your field, that's not necessarily going to be indicative of extraordinary ability. The number of papers and the period over which you have published is also going to be relevant, because the standard for EB-11 classification is sustained national or international acclaim. And immigration has interpreted that word sustained as being over a substantial period of time. In other words, you're not just a one-hit wonder. So when you're talking about the number of papers that you've published, if you've published, 5 papers, but it's been over a 15-year career, that's not going to be very impressive. But on the flip side, 15 papers in 5 years is something that may be considered noteworthy and indicative of that sustained acclaim. That also applies to review work. The more articles that you, or manuscripts that you have been asked to review by journals or conferences, if you've been on review committees for different conferences or meetings, the more likely it is that you'll be considered distinguished in your field. And also, if you've been consistently asked to review over an extended period of time, that shows that the recognition that you've received for your achievements has been prolonged or sustained. So you're not just someone who is at the early stages of perhaps rising to the top of the field. You have already ascended to that position, and you've maintained it over the course of many years. You can always volunteer to do peer review services in an attempt to satisfy that criterion relating to the judge of the work of others, but just doing a few reviews here or a few reviews there over a short period of time may not get you past the final merits determination stage. And again, that's because immigration is going to look at the evidence and basically make a subjective judgment call. Do I think that this evidence is something that establishes extraordinary ability? Do I think that this paints the overall picture of someone who has risen to the top of the field? In regards to prizes and awards, not only do student awards and scholarships not really get you past the final merits determination, they may not even get you the criterion at the first step of the analysis, because those are generally institutional awards for which a very limited group of people may qualify. So immigration doesn't necessarily consider a nationally or internationally recognized prize or award. The same goes for grants. When they think about prizes and awards, USCIS characterizes it as a recognition for past achievement, while on the flip side, they characterize grants as funding for future research, not something that is indicative of the funding body appreciating whatever contributions you've already made in your career. I would certainly argue with them about that. If you're on a co-PI on a multi-million-dollar grant from NIH, definitely make the argument, but be prepared for immigration to potentially come back and say, we don't even think that that satisfies the criterion. The criterion for lead or critical role for an organization or establishment with a distinguished reputation. Obviously, the larger the organization, the more difficult it is or could be to satisfy that criterion. Because if you are, for example, a postdoc at Harvard, you're probably one of dozens, if not maybe even hundreds. So if you are trying to argue that your role as a postdoc at this prestigious institution is lead or critical, you may want to try and focus on the laboratory that you're in, or even just a particular project within that laboratory. Because if you can draw a connection between how the project or studies that you are in a lead or critical role on are also critical to the mission of the institution or the laboratory, continued funding for the laboratory, keeping funding for the laboratory by producing certain results, there are ways to make those arguments, but you have to be creative. In regards to the reference letters, if any of you have spoken with friends or colleagues or already explored the option of an immigrant visa for yourself, you may be familiar with this concept of letters of reference from other individuals in your field. Those are generally submitted in support of the lead critical role criterion and the original contributions of major significance criterion. And they can be really useful for synthesizing all of the evidence that is being submitted in support of your petition and having the experts in your field explain to the USCIS officer why that evidence is significant and indicative of someone at the top of the field. Now, just trying to satisfy the original contributions of major significance criterion with reference letters alone can be problematic. But if the letters explain explain what your original contributions of major significance are and then tie it in with other evidence, then it's going to be much more powerful. But you want to choose who your referees are carefully. You want to have them from leaders and people who are as renowned in the field as possible. But at the same time, the more accomplished or acclaimed the referee, the person who's writing the reference letter, the less extraordinary you may appear by comparison. So that's just a bit of a balancing act that you have to do so that the USCIS examiner doesn't come back and say, well, everyone who wrote a reference letter for you is clearly at the top of the field, but their accomplishments so clearly surpass your own that there's no way you could also be at the top of that field. To get into some terms and take a step back and make sure that everyone understands the different acronyms and phrases and abbreviations that I'm throwing around, the EB-11 is a type of immigrant visa petition which is filed on I-140. You'll see there that's listed at step 1. Although people use the terms immigrant visa and green card interchangeably, the immigrant visa petition, I-140, is not actually the green card application. The green card application comes at step 2 with the I-485 application to adjust status. Or you can consular process from abroad if you're not currently in the United States. So with the filing of the I-485 green card application, you can also apply for an employment authorization document, which allows you to work for any employer or even be self-employed. Those of you who have been on F-1 visas and have had optional practical training, that's the same type of employment authorization document that you apply for in connection with the permanent residence process. You also get what's called an advanced parole travel document that allows you to travel internationally while the I-485 application is pending. Then finally, your spouses and unmarried children under the age of 21, if they are going to be applying based on your immigrant visa petition for their own permanent resident cases, they can also file their own I-485 with you. Now, there is the possibility of concurrent filing, meaning that you can file the I-140 and the 485 at the same time. That's always a personal decision that I leave up to the applicant, because the risk with that is that if the I-140 is not denied, then the I-485 is also automatically denied by U.S. Citizenship and Immigration Services. So some more cautious individuals prefer to file the I-140, wait to see if it gets approved, and only then proceed to the second step of I-485. The EB-11 does come with the premium processing service option, and that is an additional government fee of $1,225 that guarantees a response from USCIS within 15 calendar days. Now, an adjudication or response from USCIS unfortunately doesn't mean it's the answer that you are going to want, which is an approval. So it doesn't mean 15 days or less guaranteed approval. It just means that they have to communicate with you in some way, which could be an approval or it could be a request for evidence, which is something we'll talk about more later. What you see on your screen right now, some of you may be familiar with it and checking it obsessively every month if you already have a case pending. Others, it may be brand new and therefore potentially confusing. But what you're looking at is the visa bulletin. And all that we have up there are the first 3 employment-based categories. And I won't talk about the third. That is not an option, where it is technically an option for all of you, but it's not likely one that you're going to pursue. I'm just looking at the first and second here. EB-11 is in the first category, obviously, and if you look across all of the countries that are split up there, all chargeability, China mainland, India, Mexico, and Philippines, you see the letter C for all of them, and that means current. That means that immigrant visa numbers are immediately available for the EB-1 category no matter where you were born. If you look down to the second preference category, you see that that's not true for nationals born in mainland China and in India. That September 15th, 2008 and June 15th, 2008 cutoff date represents the priority date, which is, in the context of what we're talking about, the date that you file your I-140 immigrant visa petition. So currently, the green card applications are being processed for those born in India who filed their I-140 before June 15th, 2008. And that is why getting into the EB1 category is particularly valuable for nationals born in China or India, because otherwise you're looking at what appears to be, based on this most recent visa bulletin, which is for October 1st, at least a 5+ year waiting line to get that green card. And as if this weren't confusing enough, the numbers jump around. So 5 years in October doesn't necessarily mean 5 years a few months from now. These numbers are constantly being adjusted depending on how many applications are being filed, because if the demand starts to rapidly outpace the supply of the immigrant visa numbers, which are there's a cap on them for each fiscal year, then the retrogression is going to kick in, and those cutoff dates that you see there are going to begin moving backward, which means that the line for the green card, the waiting line, has become longer. So I know that's a little confusing for anyone who's not familiar with the visa bulletin. Feel free to reach out to us, but we just wanted to go over it briefly so that the difference between the EB1 and the EB2 categories, especially for Indians and Chinese, is very clear, and you have a visual representation of what the significance of that is. So speaking of EB2, we are now going to move on to the second immigrant visa option that we're going to be discussing today for self-sponsored options, and that is the National Interest Waiver, or NIW. Unlike the 3 out of 10 criteria and the 1 major award and the final merits determination, step 1, step 2, the test here is ostensibly quite simple. There's 3 prongs that you have to satisfy. You have to demonstrate that your work has substantial intrinsic merit, that the implications of that work are national in scope, and that the national interests of the United States would be adversely affected if the labor certification requirement were not waived in your case. So all of you are very smart, so I'm sure that you see that the real crux and stumbling block in establishing eligibility for the NIW is going to be that third point, because to most people, myself included some days, that standard of adversely affected, labor certification requirement not waived, it's incredibly vague and imprecise and confusing. So let's dig into that a little bit more. The third prong, the court, there's a famous case that addressed the NIW standard, and it's called NYSDOT, NYSDOT. It stands for New York State Department of Transportation. You can Google it and read the court case in your spare time if you want to have fun. And it basically says that in order to satisfy that third prong, you have to demonstrate that you, the applicant, have had some impact, some degree of influence on your field as a whole. It's not enough that your work has substantial intrinsic merit. It's not enough that the implications of that work are national in scope. We need to look at you, the individual, and not try and argue that your work in general is so important that anyone who does it should receive an NIW, but that you have some past record of achievement that justifies waiving the labor certification requirement. And that's what the W stands for in NIW. You're asking for a waiver of the requirement that you have an employer sponsor you through the labor certification process, which requires demonstrating that there are no available, able, willing, qualified U.S. workers for your position. So not only do you not have to be sponsored, but you're basically saying what I have accomplished, what I am contributing to the field, and the substantial prospective benefits to the United States from my work are so significant that even if there were a minimally qualified U.S. worker for my position, I should still be allowed to immigrate. I should still get a green card even though I may be displacing a U.S. worker. So even though that may sound pretty impressive and difficult to satisfy, it is in practice a much lower standard than extraordinary ability EB-11. For scientists and researchers, many of the same criteria are still going to be considered in the adjudication process. So you're going to want to look at your citation record, you're going to want to look at your papers, your presentations, but you don't have to reach that very high standard of sustained national or international acclaim, just some degree of influence on the field. Along the same lines, you don't have to show that you're at the very top of the field, but nonetheless that you have distinguished yourself within it and that your work has already had some impact. So it's not enough to say, well, I'm working on this and that and such, and we think that it will have an impact or has the potential to have all of these benefits. You have to show that you already impacted the field with the work that you performed in the past. Some more issues that are specific to scientists who are considering this immigrant visa option. A lot of this is the same for EB-11, but the focus is slightly shifted in NIW because the standard is lower, but it's still very focused on you as an individual. So it doesn't really matter how many papers you have because there's no final merits determination. They're not going to be doing that standard of looking at the evidence in its entirety. Does this paint the picture of an extraordinary person? But you do have to show that whatever impact those publications have had can be attributed to you as opposed to your co-authors. So if you're first author on all your papers, that's great because immigration is going to say, all right, you were given the primary credit for this published work, so clearly you must have had a large part in it. So if you have papers and you're consistently appearing, the third or fourth or, fifth or even lower in the list of co-authors, you're going to want to talk to some of those co-authors and say, hey, I really might need a letter of reference that describes what my contributions were to this work and how this work has had an impact on the field, because just submitting the paper alone is not going to be evidence of that influence that you've had on the field alone. The influence needs to be attributed directly to you. Now, a limited publication record, again, like I said, it's not necessary that you have a lot of published papers, but immigration is going to look at what your paper, what your publication record is and how it is evidenced as having influence on the field. So having just a couple papers is not necessarily going to be a big issue when you look at the citation record and see that each paper has, for example, received a number of independent citations, meaning not citations from you, not citations from your co-authors or collaborators. And then the converse may also be true. So if you have a really extensive publication record but a really low citation record, then immigration may not consider those papers to be all that impressive or relevant to meeting the NIW standard because there's not a citation record to demonstrate that the work reported in those papers has had an impact on the field. Now, citation record is not the only way to demonstrate an impact on the field, but it is certainly the easiest, because when you're dealing with USCIS examiners, you're not dealing with people who are in academia and who understand that, that industry or area of concentration and how it works, you're going to be dealing with someone who doesn't understand what it is that you do, who may not be familiar with your field, and so you're going to have to explain to them that, you know, I have only 5 citations to this paper, but that is a really high citation record for someone in mathematics or, you know, statistics. So all of this has to be clearly laid out to the officer, and numbers are something that is easy for an officer to understand. So if they see a high citation record, that to them is just a very easy way of giving someone an NIW. When you don't have that, you have a bit more work cut out for you, and you have to come up with arguments and alternative evidence that nonetheless are going to convince the officer that you have had some degree of influence on your field. This is also kind of relevant, the letters from co-authors is also relevant in the context of large collaborations. Sometimes, depending on the type of work that you do, you may be involved in a multi-institution collaboration where there's dozens or even hundreds of scientists. And so the list of the authors on a paper may take up the whole first page of the paper in whatever you know, journal it's been published in. So the larger the group in which you are working, the more difficult it's going to be for USCIS to attribute the impact of your published papers or your research directly to you as an individual. So again, that goes to the question of getting reference letters from your collaborators that clearly articulate what your individual role has been on the project and how that individual role has led to whatever impact that work has had. The logistics of filing and getting your NIW processed by USCIS is the same as the EB1, but again, there is that backlog in EB2 for foreign nationals born in India and China. So they can do the step 1 of filing the I-140 immigrant visa petition, but they cannot move on to step 2 of filing the I-485 or consular processing if they're abroad until the priority date becomes current. And as you saw in the visa bulletin a few pages back, the priority dates for China and India are currently cut off at 2008. So that means that folks who filed their NIWs more than 5 years ago now are just now having their green card applications processed. Another slight difference is that the premium processing option is not available for NIWs. So you can't pay that extra fee and get your response from USCIS within 15 days. That being said, the processing times, at least on most of my recent cases, are very fast right now for NIWs in both service centers. These cases are processed in the Nebraska Service Center and the Texas Regional Service Centers of USCIS. So they're actually quite a bit faster than the regular processing EB11s. So those processing times are subject to change. They can always ramp up or really slow down. But for NIWs right now, at least, I'm seeing adjudications within 2 to 3 months of filing. If you are one of those unfortunate individuals who is born in China or India, that doesn't necessarily mean that you should completely disregard the NIW as an option altogether. If you're at an earlier stage in your career, you may want to file an NIW now just to establish that priority date and get that place in the green card waiting line, and then eventually build your credentials up to EB11 status. I have successfully done that with individuals, including postdocs, who have gotten EB11, but it really depends on what your facts are, what your evidence looks like now versus what you think you'll have on your CV maybe 6 months or a year and a half from now. It's very individual to the specific case. Some people say, I just want to go for the EB11 now and see what happens. Others do pursue that strategy of filing the NIW to at least get a place in the green card waiting line, and then hopefully are able to get an EB11 without having to wait the full 5 or 6 or 7 years for their NIW priority date to become current. And here we are at our final immigrant visa option for scientists and researchers. This is not one of the self-sponsored options, but it does bear discussion because assuming that some of you folks out there are PhD candidates or doing your postdoctoral research, this may be an option for you within the next few years or even less time, depending on where you are in your career and your training. So this is employer-sponsored, but it's not limited to academia. Even though it says outstanding researcher or professor, this can include private industry, provided that the company sponsoring you has at least 3 full-time research positions and has documented achievements in your academic field. Before you can file, you have to have at least 3 years of experience in teaching and or research. The research experience, if you are trying to rely upon some of the time that you spent pursuing your doctoral degree or even your master's, has to be recognized as outstanding in the academic field if it's going to count toward that 3 years. Similarly, if you want to rely on teaching experience that you gained as a student, you must have had full responsibility for the class. The position that you're being offered by the sponsoring employer has to be permanent in the case of researchers, meaning that it's not for a specific duration, it's indefinite in nature. And then for professors, it has to be either tenured or tenure track. For classification as an outstanding researcher or professor, the standard is technically lower than EB-11 because you just have to be recognized as outstanding. It doesn't have to be sustained acclaim and being within that small percentage at the very top of your field. But at the same time, it is also slightly higher in the sense that you have to be internationally recognized as outstanding. So even if you had national acclaim, that would not be sufficient. You could meet EB-11 standard, but not EB-12 because that requires international recognition for your achievements. So like the EB-11, the EB-12 involves a little paint by numbers, and we are dealing with 6 criteria in this context instead of 10. And you only have to meet 2 in order to establish eligibility instead of 3. So the first 3 criteria there, major prizes or awards for outstanding achievement in the academic field, membership in associations in the academic field that require outstanding achievements of their members, published material and professional publications written by others about your work in the academic field. So those criteria probably look familiar. They're quite similar to the EB-1 criteria, but you'll notice some small differences. So for published material, it just has to be about your work. So immigration can't get quite as stingy with this criterion as they do with the EB-11, saying, oh, it doesn't mention you by name, it's not primarily about you, so on and so forth, because it just has to be about your work. Similarly, skipping to the second criterion that you see there on the page, original scientific or scholarly research contributions to the academic field. It just has to be an original contribution for EB-12. For EB-11, it had to be of major significance to the field. So sometimes you may be dealing with an immigration examiner. Perhaps they are more familiar with the EB-11 standard, or they do EB-11 and EB-12 cases. Make sure that they're actually applying the correct standard here, because you only have to show that your contribution is original. Don't let the USCIS examiner tell you that you have to also show that it was of major significance. Going to the top there, participation as a judge of the work of others in the same or an allied academic field, again, very similar to the EB-11 criterion, and authorship of scholarly books or articles in scholarly journals with international circulation in the academic field. So a slight twist on that one, it has to be international journals. Just a professional publication or major media is not going to suffice. There has to be that international aspect to it because EB-12 requires international recognition. There's that final merits determination rearing its ugly head again. Unfortunately, it does apply in the EB-1-2 context. We were safe and sound when we were talking about NIWs, but now we have to consider, all right, I've met the 2 out of my 6 criteria, hopefully even an extra 3rd or 4th criterion to give me a little wiggle room, but still at this second stage, we're going to have the USCIS examiner look at all of the evidence in its entirety and question whether it is indicative of someone who is internationally recognized as outstanding. So the same issues that the officer may nitpick on at this stage in the context of EB-1-1s for scientists can also be raised here. So do you have review work? Yes, but is it just a handful of reviews over a short period of time? Uh-oh, I may be called out on that during the final merits determination, and you have to be prepared with your counter arguments in case immigration tries to say, we're going to give you that criterion, but we're not going to determine that it passes this analysis, and you're going to have to convince us of why this evidence nonetheless paints the picture of someone recognized as outstanding on an international level. And really where you see that primarily is in the RFE context. RFE stands for Requests for Evidence, and they're not uncommon in the EB-1-1 context at all because the standard is so high and so subjective, and the examiners are given so much latitude in how they apply that final merits determination. In the NIW context, I personally have never had an RFE, knock on wood, but that does not necessarily mean that they can't be issued or that you can't receive an approval in case one is issued. It really, again, has to do with how well you prepare your case, but even if you do have a beautiful case, an RFE still may be issued, so it's not necessarily cause for panic. You really want to read the RFE carefully. I think that based on certain comments that I've made throughout the presentation thus far, you probably realize that I talk about, fights with USCIS and going back and forth about what a criterion really requires, what is it appropriate to nitpick or issues to raise during the final merits determination. In the RFE, there is a lot of the time a lot of ammunition that you can use in your RFE response. If the officer did not apply the correct standard, if they are trying to add requirements to a regulatory criterion that aren't really there, you need to address that and need to correct the officer so that you're creating a record, a case record that is accurate, because what the officer says doesn't, make it law. They make mistakes. So you really want to read the RFE carefully, and you also want to read between the lines. What is the officer really asking me for? What are they really concerned with? A lot of the times these RFEs are just copied and pasted from templates that the USCIS uses, but some of the times the officer actually does a little bit of work and will put in some comments or an individual analysis of your evidence. And when you read those statements, you can really sometimes glean insight into what the officer is thinking and why they may be disinclined to approve your case. And once you understand what the officer's concerns really are, that puts you hopefully in a position to completely dispel those concerns with a solid RFE response and some additional evidence. So again, don't assume that the officer did the job properly. If the RFE indicates that the officer failed to consider some evidence, especially if it's your most important or probative persuasive evidence, you want to bring this up. So sometimes in preparing an RFE response, you may not even submit any new evidence. You may just resubmit evidence that was included in the initial filing and that you think that the officer either did not consider at all or failed to give due weight to, either because perhaps they just missed it entirely and it was just one sheet of paper amongst hundreds of others, or they just didn't understand the significance of the evidence. And the RFE response gives you a chance to further explain and give the officer a clearer understanding of why the evidence is something that shows you to be at the top of your field, or to have had an impact on the field, or to have garnered international recognition for your achievements. One thing, and I think I raised this already when I was mentioning the reference letters, we see this template language often in RFEs with the officer complaining, oh, you're trying to rely only or primarily on reference letters to show that you've met the original contribution criterion. And while that can be a big part of the case, because again, the experts who are writing these letters are in the best possible position to explain why your contributions are original or significant, you nonetheless want to make clear to the officer that this is just one piece of evidence that describes what my contributions are, and those letters corroborate the other evidence that is submitted with my petition. So when this reference letter is talking about my paper and how important it is, that is supported by the fact that that paper was published in the third highest ranking journal in my field with an impact factor of 10.5. So you want the officer to really look at the evidence as a whole and do what they're supposed to do at the final merits determination, but do it to your benefit instead of trying to hold it against you. So we've reached the end of our webinar now, and I do have time for some questions. We've set aside 15 minutes here, so if anyone has any questions, please go ahead and type them, and they'll pop up on my screen here. What you see there on your screen is my contact information. If you had to jump off the webinar early, then you can't hear me saying this right now. But for those of you who are still listening and you're not able to send me a question online, please feel free to contact me. Again, I'm Jessica Marks. We are Wolfsdorf Immigration Law Group. These webinars are saved on our website, so you can certainly listen to it again. We have offices in Santa Monica and New York. Please feel free to contact me, and you can set up a consultation with me over the phone, or you can come to our Santa Monica office. That's where I'm located. So it doesn't look like anyone has any questions today. That must mean that you're all experts, and I did a fantastic job of describing all of these immigrant visa petitions. I hope that's true. So like I said, if you do not have time to put in a question right now, or a question comes to you later after you've had some time to review the slides and think about these options, please feel free to contact me, jmarks@wolfsdorf.com. Thanks again, everyone.